Welcome, viewers and listeners, to another edition of CHP Talks. Here we are launching still into the first month of 2026. We don't know what lies ahead. There's already quite a bit happening in the world and in our country in the few short days of this new year. But we have with us a very special guest, the Honorable A. Brian Peckford. And Brian, thank you for taking the time to join us today.
My pleasure.
Yeah, super. I'm going to give you a bit of an introduction. Those who have heard you before will be familiar with this, but I think our viewers and listeners need to know who you are. So, the Honorable A. Brian Peckford, PC, was born in Whitburn, Newfoundland. At the age of 29, Brian was elected to the House of Assembly of Newfoundland. In 1979, Brian became the third Premier of the province and, at the age of 36, the youngest First Minister of Newfoundland since the first Prime Minister, Philip Little, in 1855. So Brian became, as Premier of Newfoundland, a strong advocate of provincial rights, and his efforts to gain revenues for the province from its offshore oil and gas resulted in the historic Atlantic Accord. Brian was also involved in the constitutional patriation process of the early 1980s, leading to the Constitution Act of 1982 and our existing Charter of Rights and Freedoms. It was Newfoundland's proposal that led to the breakthrough. Brian is the only living First Minister signatory of that constitutional process. He was sworn to the Privy Council by Her Majesty Queen Elizabeth in 1982. And we came to know him during the dark days of COVID. Brian became an advocate, an outspoken advocate for freedom. He supported the truckers' convoy, stood up against the mandates. He's fought for legislative and judicial adherence to the letter and the spirit of our Constitution. Brian and his wife Carol have provided much encouragement and valuable perspective to many of us in the ongoing fight for the rights and freedoms of all Canadians. So it's a real pleasure and an honor to have you with us today, Brian, and thanks for your work. Going back, thanks for your work as Premier of Newfoundland, and also for your work in establishing the Charter of Rights and Freedoms. One of the things you and I have spoken about in the past, and it's quite a significant topic, I believe, is the supremacy of God and the rule of law. For those who may not be familiar with the wording of the opening of the Charter of Rights and Freedoms is, whereas Canada was founded upon principles that recognize the supremacy of God and the rule of law. Both very important. Those are foundational statements. The rest of the Charter seems to rest on those. But there are people today who do not recognize that, and some of them are in high positions of authority, not only in the Parliament and legislatures, but also in the courts. And you brought to my attention a case going on, or a significant something that took place in Alberta not very long ago. And would you want to tell the people about Roger Song and his appeal to the lawyers of Alberta?
Yes, Mr. Song is a former Chinese communist person who was born and raised in China, but then when he got into law in China and became a professor, he realized, of course, that his freedoms and his ability to speak freely were being constrained in that society. And so he left it and came to Canada to gain more freedom and more liberty, which he understood existed here in Canada. And so he became a lawyer in Canada, trained to be a lawyer in Canada, and is practicing law today in the province of Alberta. However, through his activities, he has to be, of course, under the laws of the provinces, a member of the Law Society, or if it's a doctor, of the right, College of Physicians and Surgeons, and so on. You had to be members of these professional organizations, which are set up by an act of the legislature of each of the provinces. And so Mr. Song, obviously, is a member of the Law Society of Alberta. Well, the Law Society of Alberta is starting to get very aggressive on how it deals with its membership. And it started to bring in rules and regulations which govern their behavior, not their legal work in the courts, not their legal work or being a good citizen. All of that is automatic and must happen. But they're going to start to regulate, or are now regulating, what you sort of believe and the beliefs that you have and whether they conform with the beliefs of the society. Well, he saw this as a direct challenge to individual lawyers in the province of Alberta, and brought an action against them, saying that this is wrong and it doesn't conform with the Charter of Rights and Freedoms, where you're free to speak your mind, right? You have freedom of speech, freedom of expression, and liberty, and those provisions of the Charter. However, that challenge to the Law Society's power was upheld by the Supreme Court of Alberta. And now it's being appealed by him through the Constitutional Justice Center for Constitutional Freedoms. They're helping him appeal this decision to the highest court in Alberta, the Court of Appeal, and that's where it sits today. And that was brought just before late 2025. And so that sits there today to see whether the appeal court will have the gumption and the wherewithal to stand on principle and to stand for the Charter and the rights of individual lawyers to hold various ideas and beliefs and still be a good member in good standing of the Law Society. Meanwhile, he initiated as well a resolution at the last annual meeting of the Alberta Law Society in November 2025, just 2 months ago, in which he asked the Society to pass a resolution which would acknowledge the words that are already in the Constitution, the supremacy of God and the rule of law, and that they would honor them in the practice of their law society and in their functioning as lawyers in Alberta. And he thought it was really, given what was happening in some of the court cases and so on, he thought that this was very important to have the Law Society acknowledge that this is part of our Constitution and must be considered when we're talking about operating the law and practicing the law in Alberta. And so he initiated this resolution, which forced a vote. And the vote on November 27th, 2025, like I say, not even 2 months ago, there were 496 lawyers who voted. 453 voted to turn that down, to reject Mr. Song's resolution to honor the supremacy of God that's already in the Constitution, and 43 supported it. So he lost this action before his own Law Society. This will give you an idea of just how far we have gone. That in a province like Alberta, which is perhaps one of the more conservative provinces in the whole country, the Law Society, by a massive majority, was not prepared to accept that the supremacy of God, which is in the Constitution now, not asking them to try to put it in their bylaws but it wasn't in the Constitution. It's already in the Constitution. Right. Just acknowledge its presence there and to use it and to operate under it in their activities and in their behavior. And in the arguments that were made by those who opposed doing what was right and what was supporting the Constitution, they quoted a Supreme Court judge in British Columbia. They supported a judge there, Madam Justice Southin, Southin, in an appeal decision that she made in 1999. The appeal was, the name of the appeal was R versus Sharp, 1999. And in that, in discussing and making a ruling on that particular case, she said, supremacy of God in the Charter had become a dead letter. No court, and the court has no authority to breathe life into these words, the supremacy of God, for the purpose of interpreting the various provisions of the Charter. Now, she has no power to say that. It's already in the Charter, and all she's supposed to do as a judge is interpret the words that are there.
Yeah.
Not say that it's no longer there. She has no eraser or no power to eliminate what's in the Constitution. That can only be done, by the way, by the First Ministers, 7 out of 10. That has to be done by the amending formula that we put in the Charter in 1982. Here we have an example now, both of them concerning Mr. Roger Song, a lawyer in Alberta who has, number one, taken his Law Society to court to try to stop them from compelling him to believe certain things in order to be in good standing before the Law Society, number one. And number two, where he actually went to his Law Society annual meeting and tried to get a resolution passed recognizing the supremacy of God. He's lost in his society, and he's still fighting the society's rules before the appeal court of Alberta, and that hasn't been heard yet, and no decision has been rendered on it. But up until now, the Supreme Court of Alberta has supported the Alberta Lawyers Association against Mr. Song. In other words, opposing, recognizing what's already in the Constitution. So really, if you really look at this for what it is, all of these people who have opposed this should not be entitled to be lawyers in the province of Alberta, because they are violating and ignoring provisions of the Constitution which they're supposed to accept in order to become a lawyer.
Yeah.
So this is an amazing turn of events, but it highlights just how far the country has gone away from the principles of the constitutions, and more particularly in our case, given our history and culture of being based upon the Judeo-Christian society, how we now are prepared to ignore our history, ignore our traditions, and ignore provisions in the Constitution, and to become completely a secular society with no moral framework from which to operate.
Yeah, because if you take away the supremacy of God, or the idea that there is a gracious, all-knowing, all-loving God who presides over humankind, who made us in His image, and who made the world and gave us everything that we need for life and godliness, to reject that, and you mentioned this Supreme Court Justice in BC, Justice Southam, and to just make that statement, well, this is a dead letter. No, that expresses more of a personal opinion, of course. That's her personal opinion. But like you say, what gives her the right, just because she has an opinion, to make that, the new law of the land?
If she was talking at a dinner table amongst her family and confided in them how she had concerns about that being in the Charter, is one thing. But to rule it from the bench, she actually commented on it from the bench when she was giving a decision, which gives it the kind of weight that therefore the lawyers could use when they were trying to argue to eliminate the supremacy of God. Because she was the top judge in British Columbia, and she was ruling from the bench, and she has no power or no authority to even say that before the bench.
Right.
It's off limits because it's already in the in the Constitution, and she has no power to change it.
And first of all, I have to give a lot of credit. Thanks for bringing this all to my attention. But this Mr. Rogers song takes a tremendous courage for him to take on the whole Law Society of Alberta, and he has every right to do so. But many people would not do that, even if they thought they were right. They would not want to challenge the opinions and possibly, develop a reputation, be diminished in their reputation among their own law society. But of course, coming from communist China, he's seen this video before. He knows what it's like to be told what he must think and what he must do and how he must behave. And he came here for freedom. And it's amazing that
yes, and let me just add to that, which I think you will find even I don't know about more interesting, but very interesting, is that he is a practicing Christian, and he's involved with a whole bunch of Christian churches in Alberta, which this coming year in 2026 he's hoping to get together and have a convention concerning the necessity of the supremacy of God as part of our life, as part of our Constitution. And he's asked me if I would speak at it, if in fact he's able to bring this together. And so, of course, I will, gladly. By the way, that is in contrast to, and now that we're on the talking to the people who listen to your program, they might also be interested at the same time as hearing what I just said about what Mr. Song is trying to do, and to keep alive the whole concept of the supremacy in God and its absolute necessity for our society, both in the Constitution and through our various organizations like our churches and so on. But not only is he trying to do that and keep that alive, but I just had, in the last couple of weeks, when this was happening, a notification from an organization in Alberta again, where they're having a big convention in May, where they're going to be doing, it's an organization that does debates and discussions and stuff on public policy and the like. And they've contacted me because they have decided that they want to do a resolution which says, be it resolved that the Charter of Rights and Freedoms is useless. Wow. I have refused. I have written them back and said I will not engage or participate in any kind of a debate where that kind of formulation is made. In other words, you've got me attending. No doubt there's going to be a lot of people there who, like the Law Society, want to get rid of the supremacy of God and all the rest of it, and a lot of the Charter of Rights and Freedoms. Well, I'm going to be a target, right? Because they want me, obviously, know that the only argument I would make on that would be against it. And so they wanted me to argue the negative and have somebody else argue the positive. But in the climate of today and in the climate of Alberta, and the climate obviously said, or to even entertain it. Now, if they were going to entertain something along the lines of, we know we have the supremacy of God in our Constitution, but we know we have a lot of rights. Hundreds and hundreds of cases have been decided in the favor of citizens have really benefited from the Charter, and it's now under attack. And would you like to take a position of the Charter, notwithstanding all the attacks, is very worthwhile, and have do that. I'm not prepared to take part in something that's already cited against me, and I'm not going to entertain the negativity of the supremacy of God or the Charter of Rights and Freedom. So here we have now a lawyer from communist China, who's now a Christian and who is a part of Christian denominations in Alberta, going to court and going to his own law society to try to defend what's already in the Constitution. On the one hand, supremacy of God, blah, 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 and is going to try to have a conference celebrating this. And now another group in Alberta who are trying to have a conference where there's going to be a debate and have somebody argue that the Charter of Rights and Freedoms is useless. It's no longer valid, no longer any good. So
I think when last time you and I spoke about some of these questions, it has to do with if they're not living by the charter, like if the courts are abusing the charter and politicians are twisting it to their own ends, and this is in a lot of areas, not it's in the area of Indigenous affairs for one thing. It's but to ignore the supremacy of God kind of takes the wind out of the sails. How are you going to, if you think the God of right and wrong, the author of of right and wrong is going to be
fair?
Yeah, how can people reject God?
How do you frame a moral order? How do you frame a moral society?
Yeah, because everybody has a conscience, but those who reject God, what do they base their conscience on?
Exactly.
Somebody will say, well, it's wrong to let your car idle, and pollute the environment. Well, why is it wrong if there's no supreme being who cares?
Exactly.
In
other words, then it gets manufactured and changed however that leadership of that time wants it.
Exactly.
And it gradually will, sink into a very, very unfortunate, right, and immoral kind of society. It always has and always will be.
Yeah. So, did you say when this appeal, Roger Song's appeal, is going to be heard?
It hasn't said online when it's going to be heard.
Okay.
But it was presented to the court. I'll get it for you here now. On October the 9th,
okay,
2025, the decision from the lower court was appealed to the Court of Appeal.
Okay. Yeah.
Okay. And it hasn't been heard yet, according to what I can find. I went in on the court website to try to find any recent decisions, and it wasn't there. So I assume that final decision has not been made yet.
Yeah. You probably are aware that we also have an appeal being heard in the Ontario Court of Appeals. On February the 3rd, our appeal will be heard. This is with the city of Hamilton, who refused to allow us to put up a poster that said woman and adult female. And even though they acknowledged in their letter of rejection, they acknowledged that that's a definition that can be found in most dictionaries, but because of political correctness and their concern about what people might say, certain people might say to them, they refused. And we surprisingly lost at the judicial review at the lower court, but we can't let that decision stand. So we will be presenting our case to the Court of Appeals on February the 3rd, and we hope that justice and common sense will prevail there.
Well, do you have a group of a lawyer representing?
We have the Acacia Group is representing us. Leah Malusis is our lawyer, and we're quite pleased with her. She's done a very good job. She did an interview with Ezra Levant on the topic some time ago, which is on our landing page and so on, and we're confident. I mean, if they do the right thing, we'll win.
Oh yeah.
And
problem is they hardly ever do the right thing anymore.
Yeah, The courts have been twisting and allowing the provisions of the charter to be twisted out of recognition.
Yeah. Yeah.
And if they don't turn around and start doing the right thing,
Yeah.
we will not have. The supremacy of God is important, but so is the rule of law, and the two are tied
Absolutely.
together at the hip. If we lose the supremacy of God, we will also lose the rule of law.
Absolutely. It becomes so loose and goosey
Yeah,
and changeable with no fundamental principles guiding us, into the future. It's just unbelievable. And you're right when you say because the supremacy of God is the opening words of the charter. It's the opening word. And by the way, it doesn't say preamble. Other people have said that. It, part one of the charter, the first words after part one is whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law, colon. In other words, everything comes after that. Everything is
exactly.
subject to that. And this is what everybody tries to forget every time I mention it at speeches or whatever, not with you, but with others. They try to ignore me when I talk about that. And that proves, and I remember I was there. I was there when this was approved. I'm the only one alive who was there when this was approved. I remember that. I remember that. That was deliberate on our part. And the sad part about it now, Rod, and I'm glad you're recording this, and hopefully it'll be kept for when I'm gone and you're gone or whatever, so that there is some record from a person who was actually physically there and approved it on behalf of his people and his province.
Mm-hmm.
Okay,
Yes.
I was there, so this is very important to me because I remember it, and everybody agreed. Everybody agreed to that provision being in the charter. With other parts of the charter that Levesque agreed with, and finally couldn't approve the whole thing. But on an individual basis, they had agreed to that.
Okay.
So I mean, this is and it is the introduction, the framework, because that colon proof, we didn't put a full stop there. We put a colon there. Everywhere else you got full stops, but not there.
Yeah.
You see, it's obvious, right, that it was deliberate because it's not anywhere else.
Right.
It's just so obvious. And so the other thing is that so right from the get-go, the Constitution was being undermined, and then that Section 1 during COVID, right, where nobody who brought in these mandates and lockdowns actually proved that they needed to do this. And under the Section 1, it says you must demonstrably justify.
Yeah.
Nobody demonstrably justified. There was no thing done to demonstrate that. There's no document. All these lockdowns and were done violating the Constitution, violating Section 1. So, and the other one, which is now current, is the business of the Indigenous rights. And I just want to point out for your listeners and your viewers that under the Indigenous rights, they might forget what it says. It's very short. The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Had nothing to do with title. And the early decisions under Section 35 by the courts had to do with consultation because of their rights, because they had been there. Those kinds of rights. It had nothing to do. Rights and title are two different concepts altogether. And all we were talking about was their rights that they were there, the rights that they should be consulted, their rights in some cases must be accommodated. In other words, they must be brought into the development, not to say yes or no to the development on their land, but to be involved in it, in the development of their land. It had nothing to do with them having title and therefore had a veto power over that thing. And the only other thing that says in that section 2, is In this act, Aboriginal peoples of Canada refers to the Indian, Inuit, and Métis people. Up until then, there was no definition of Aboriginal in the Constitution. So who are the Aboriginals? And this was deliberate on our part to define who they are. Everybody knows who the Indians are. Everybody knows who the Inuit are. They were, in our day, Eskimos. And the Métis people, who were the mixed breed between the whites and the Indian people, right? Mainly in Manitoba area. So that's all. It was identified who was Aboriginal, and it was identified that their existing rights and treaties should be affirmed and recognized. That's all. That's it.
Yeah, yeah.
See what's happened. The judges have taken that section and has completely enlarged it, massacred it, brought it to whatever it is. Their own idea is not what the Constitution says.
I know another part, and I don't have it in front of me, but under Jean Chrétien, the whole sense of protected, individuals are protected based on sex, race, various characteristics. The word sexual orientation is not in the charter, was not in the charter that you approved. Your fellow signatories approved, but that was brought in by a prime minister who said, well, it should have been there.
Yeah, but that's no good.
Yeah, and
that has no bearing in constitutional law.
Yeah, so again, twisting of words and inserting phrases they want and taking out phrases they don't want, that undermines the Constitution.
That never happened in the United States. That would never happen in the United States. That's never happened.
Yeah.
This kind of thing that we're talking about now has never happened in the United States.
Yeah.
This is unbelievable. I mean, so this is how far we've gone. Yeah. So you just take those three things alone, right? Just take the opening words, which introduce the charter, right? You take section 1, there can be exemptions, but only if it's demonstrably justified. And I remember, as you heard me say before on your program a year or two ago, where I said, we deliberately put demonstrably justified in there. It was only justified before when we had different drafts, but we deliberately put it in there to make it stronger. Right?
Yeah.
You have to demonstrably justify before you can, for temporarily relieve yourselves of these rights to the people, right? And that's never been done. And then thirdly, the Section 35.
Yeah.
As well as all the sections dealing with speech and right and freedom of thought and freedom of expression, freedom of assembly, liberty, and all the rest of it.
Yeah. And there's other things I would love to get into. You've been very generous with your time, and I don't want to abuse the privilege of having you on the program. Maybe another time we can talk a bit about the notwithstanding clause and even about the history of the charter, how it first came into being.
I can just barely touch upon the notwithstanding clause, because that's extremely important. Without the notwithstanding clause, there would have been no charter.
Yeah,
that was a deal breaker for the majority of the premiers. There would have been no deal. That's why when Trudeau was forced back to the table after he lost in court, he was totally furious about that notwithstanding clause and didn't want it because he wanted to have the final say was not going to be with the provinces, as if the provinces suddenly weren't provinces anymore.
Yeah.
Right? And so, but we were adamant, and he knew that he had to just bow to our will on that. That's what people forget. So everybody gets all upset about it and saying, but that's the nature of our country. We're a federation where certain powers stand with the provinces, certain powers stand with the federal government. And this notwithstanding clause stands with the provinces. But everybody doesn't want to mention this either. It has to be done through the legislature, through the people's house of that particular province if they're going to enact the notwithstanding clause. And it can only be for 5 years, and they got to repeat the process all over again if they want to repeat it for another 5 years through the People's House or democratically. It's done democratically through the Assembly or through the Parliament, which is completely different than anything else. So when people say this is somehow crazy or whatever, it's not crazy at all. Now, what other people don't understand or forget about is a number of the reasons why we wanted that at the time was, number one, Trudeau had left us and tried to do it on his own. So we were scared that in the future, right, some federal government would try that again with a more liberal, right, with a more flexible court, and therefore get us away from wanting certain things in our provinces that other provinces didn't want. Let me give you a really fantastic example. And this happened when I was in office in Newfoundland. The government of Canada had started to bring in various manpower training programs. You have heard of them, I'm sure. And they've been brought in and financed by the federal government, sometimes with some money from the provinces, but largely from the federal government, and placed in trade schools, vocational schools, technical schools right across the country, and helped to educate or train various, especially tradespeople and the like, okay? Mm-hmm. Well, what happened in Newfoundland, because we were into arguments with the federal government at the time over other things, including the Constitution, but also including hydropower and offshore oil and gas, and we weren't on good terms with the federal government. They brought in a new manpower training program that was going to apply to all the provinces except Newfoundland.
Oh, really?
And they were going to exempt fish plant worker training. And of course, what was at the time the most prolific trade in Newfoundland, in the rural communities especially? Fish plant workers and quality control, and that they must be trained before they can process fish. You can't go in and just process fish on your own. You had to have certain standards, environmental standards, safety standards, and the like. We weren't going to be financed, and we were in one of the poorest provinces in Canada. So we never had the money to do it all on our own, to the extent that was necessary to do. And so I had to fight that. I won the battle, but we had to fight that. So this is the kind of stuff the federal government can do from time to time as they moved into more and more activities that used to be handled by the provinces: manpower training, health care, social services, and all that. So at any point in time, they may decide that certain provinces don't qualify under their new terms. And this province does, but that province doesn't. So we were going to be subjected to very selective judgmental decisions by the federal government over something which was really important to our province. Yeah. There's a really good example of what can happen and why we were scared, because the federal government had already broken off negotiations and was trying to do even the patriation and the charter on its own, completely on its own, and then doing these individual manpower training or whatever, health care program or social services program or whatever, where they could, if they had wanted to, set up certain terms and conditions which eliminated certain provinces because they didn't like them.
You know, human nature, and especially the nature of those in power, is something that we always have to be aware of.
That's why you need rules. That's why you need constitution.
Exactly. The rule of law.
That's why you need God. Not only need God, God is absolutely a part of our very existence.
Very, very good. Absolutely. Well, Brian, that's a good note to leave this conversation on, and I appreciate you taking the time. God bless you throughout 2026. Give you strength and courage. Thank you for standing up for our rights and freedoms all this time. And
Rod, you know something? If I was able to do across Canada on CBC or CTV or something for a half an hour, what we just did, there'd be a lot more people in Canada understand their Constitution, and it'd be a lot more favorable towards the supremacy of God and all the other provisions as they are written in our Constitution. The mere fact that I'm shut out, and people like me, from even having my letters published now, and shut out from the courts won't hear me.
Shameful. Shameful. Well, I will invite the CBC to take this video and play it across the country. That would be wonderful. We haven't had that kind of welcome from them for our ideas yet, but you never know. Could be a year of miracles.
Let's hope so.
Okay. Well, God bless you, Brian. Thank you so much.
God bless for having me.